recessed last week. And the purpose of the meeting is to see if either of the commissions are prepared to make recommendations on the negotiation of the amended contract.
Mr. Chairman, I asked Assistant City Attorney Lyon to come down, and I'd like to just cover that very quickly, so she can go back and do her regular job and get out of here if you don't.
Sure.
Okay. That would be so great because I am so busy up there right this week.
That's fine.
I'm Peggy Lyon, Assistant City Attorney, and I have to say that this has been a very interesting meeting. These joint boards, I think we've dealt with some issues that we had never dealt with before. And for a government wonk like myself, it's been fascinating and interesting to do the research.
Okay. In the Utilities Commission meeting 2 Mondays ago, we asked for the underlying spreadsheet so we could do look at the analysis in a little more detail. And just for the record, I want to reference the mission statement of the Utilities Commission. It's fairly long. I'm not going to read all of it, but I think there's 2 pertinent sentences. In performing its mission, the Commission shall initiate and provide its own proposals, recommendations, and alternatives to the City Council. In addition, the Commission shall also review and constructively critique all proposals from city staff, consultants, and the public, and make its own independent recommendations on such proposals in order to provide the best and most complete information possible to the City Council. So when on Monday, Mr. Wright came in and said that there was a reluctance upon the consultant, Mr. Harrington, to hand out the information that was confidential. I objected to it, but in the interest of trying to move this process forward, he said he'd come up with a non-disclosure agreement and that we could sign it and move forward. And frankly, I was expecting a non-disclosure agreement that was 1 page that basically said, we're going to get it. We're not going to hand it out to anybody else. When we're done done reviewing it, we'll destroy it. Instead, we get this 6-page agreement that only a lawyer could love, talking about electronic control logs and other things like that. And to me, what the most disturbing part was when you get into Section 6 remedies, and knowing a fair amount about the law in my prior job, you see the infamous hold harmless clause in here. It says each party agrees to defend, indemnify, and hold the other harmless for any claim or liability, civil or criminal, brought or imposed on such other parties by any person caused by resulting from breach of this agreement by the indemnifying party, including any person to whom the indemnifying party granted access to designated confidential information under the terms of this agreement. Furthermore, nothing herein is intended to restrict any remedies available to the owner of designated confidential information for the unauthorized disclosure, dissemination, release of proprietary information by any of the parties to this agreement. Now, all of us members on this commission, as far as I know, are volunteers and we don't get paid. And we're trying to do this to try to move the process forward. If I sign this agreement, and I think each of you may have a different perspective, but if you sign this agreement and somebody sues out of the blue, you're required to defend against it and put your own financial well-being and that of your family at risk. And I find this incredibly objectionable. And that's the reason why I asked you down, Ms. Lyon, because there is a email from Chef Wright where he stated that, as was discussed at Monday's joint meeting, attached for distribution to the members of the Finance Commission and Utilities Commission is a confidentiality agreement that Bill Harrington is comfortable with and that Peggy Lyon has reviewed and commented on, with us having incorporated Peggy's changes. So I guess my question to you, Ms. Lyon, is how can you expect us to sign an agreement like this where we take on personal exposure, both potential civil and monetary? The city's not the party to this agreement.
It is a very tough agreement.
Okay.
The
well,
only
then why did
changes
you-
that I made to the agreement were adding in information regarding the public records law and the sunshine law, just to make sure it comported with law. But this is under Florida law. This is a confidential and exempt item that you are asking for, and Mr. Harrington has every right to protect himself and protect his information. So I would suggest it would be Mr. Harrington that you would wish to address as to the terms of the agreement that he wants you to sign in order to give you this confidential and exempt document that you're requesting.
Well, I question whether it's confidential and something in the spreadsheet. I believe it's work product that the city of Vero Beach ratepayers paid for.
Well,
and that they have a right to see it.
He's stating that it's a proprietary, confidential business information, and he's declaring it a trade secret. And once he's done that, it falls under the Florida statutes as confidential and exempt, and it's up to him to demand the terms for release of the document.
Well, I would argue to members of the commission, at least Utility Commission, based on our mission statement, that we cannot constructively critique the proposals from the consultant without being able to look at through the underlying numbers, because with the equations you get the assumptions.
I would agree with that, and I would think, Ms. Lyon, that part of your job would be to give us access to work with Mr. Harrington or his lawyer in order to give us access to this information. We need this information. And I agree with Mr. Arwar. We're not going to be subject to criminal charges for reviewing information.
It is a very, very tough document.
Well,
he has asked you to sign in order to get this information.
But
I'm sorry.
No, I would think, though, that would fall within your realm to work with him to make that information accessible to us.
My question is, does the contract that the electric utility has signed with him allow that to do that? Was it drafted in such a way, or is he asserting a different right that is not in that contract?
I would have to ask Mr. Wright, because I have not seen that contract.
Did anybody from the city review it?
Is he your consultant?
Correct. He is our consultant.
Okay.
Through me, through my firm.
Okay. Perhaps those questions could be best addressed to him.
Yeah, but it definitely impacts how we do our job.
It prevents us from doing our job.
Our agreement with my firm's agreement with Mr. Harrington is a simple engagement letter. I don't think it addresses confidential information of this sort. I've discussed this both with Ms. Lyon and with Mr. Clement, who's on his honeymoon. And Wayne's position is that he's not sure that you've got all the results. That's what you paid for, and you've been offered access on the terms of this confidentiality agreement, which is a fairly, I will tell you, we drafted it in an effort to expedite getting you all access to it, and got it out as quickly as we could. It's based on a very standard confidentiality agreement that we use frequently in matters at the PSC. That's what it is. That's where it came from.
And usually it's a corporation with a lot of assets that are signing off on it, not a public citizen. So.
Well, not volunteer public citizens like yourselves, but the typical agreements apply not only to the corporations who are the signatories, but also the standard agreements that we have. We took it out here because it didn't apply. There's a specific individual acknowledgement and agreement to be bound by the terms of the confidentiality agreement that each and every person who sees the information must sign before he or she can see it, with these terms. Wayne's position is that he doesn't believe that the underlying spreadsheet is a public record. He thinks the output is, which you've had for weeks. And you asked for access to the spreadsheet. I asked Mr. Harrington. He was reluctant because, as I said on Monday, he doesn't want his competitors and his other clients to have this, or other potential clients, to have ready access to this if it were to be released to the public. We adapted, my law partner and I adapted the form of confidentiality agreement that you have to meet this situation as quickly as we could. You asked for it on Monday. I sent it on Tuesday, and I think it got to you all either Tuesday evening.
Wednesday.
Wednesday. Okay.
Yeah.
Any other questions from the commissions? Bob?
No, I'm fine. I just wanted to lay that out there, what the risk is to everybody on this dais and at this table.
Well, thank you very much.
Are there any other questions for me that I can answer before I scoot back?
Thank you for coming. Thank you for coming.
Thank you.
Before we get into Mr. Wright's presentation, is there any other comments that any of the members wish to address?
Yes, Mr. Chairman. And this is actually a perfect segue. Thank you, Mr. Awar, for acknowledging our lack or difficulty at obtaining the proper information. I have a few comments to make, but then I would invite the other members of the commission. This is our time. We don't get to talk to each other with respect to the Sunshine Law. So I thought it might be helpful for us first to have a discussion ourselves, if anyone else has anything to say. But with regard to my position on this, we don't have due diligence. We still don't have it because we were not able to obtain the RFPs, which the people who are advising us told us were very important. Mr. Thomas, Mr. Wright, Mr. Harrington, if you look at the minutes of previous meetings, all stated that going out for RFPs was very, very important. And I'm going to quote Mr. Thomas on this, and this is from June 9th, and these are the minutes. One of the reasons they looked so closely at the go-to-market scenario was the due diligence to make sure the city was not shooting themselves in the foot by just negotiating with a single supplier, OUC, which is a situation in which we find ourselves because of the threatening letters that were sent after the RFPs went out. The threatening letters, by the way, you want to talk about criminal, those letters, in fact, could be viewed as criminal, not the disclosures that we might have to sign. But if you look at Florida Statute 836.05, which deals with threatening letters and similar offenses, it speaks about threats. Whoever, either verbally or by written or printed communication, maliciously threatens to accuse another of any crime or offense with intent thereby to extort money or any pecuniary advantage whatsoever, or with intent to compel the person so threatened or any other person to do any act or refrain from doing any act against his or her will. And I think, in my opinion, a case could be made that that's what we were subjected to. We were not able to do due diligence. We were threatened, for which something we should not have been threatened. We should have had access to that information, just as Mr. Arwar is arguing for the spreadsheets. But, of course, this is on a much greater scale because these are the fundamentals. And beyond that, I think we felt under duress that our position is not strong, when actually it is, because there's another legal issue, which is vitiation. And that is, just in a nutshell, if the context in which the contract was signed changes significantly so that contract cannot be honored, there's no reason to, you're not bound to it at that point. I mean, you can argue successfully against it, and it has been used many times in the legal and business worlds to remove oneself from a contract. So there are legal issues that are in our favor. That would be my point about this. And we are not taking the advice, or the original advice of Mr. Wright, and the advice of our paid consultants with these RFPs. We don't have them, and I think that's a real problem. And I think a lot of us have felt under duress these last few weeks. We've had 3 meetings in 2 weeks. And if you look at the 5 months before that, from May through September, we had only 2 meetings. So I don't think that it's the proper context for careful, thoughtful analysis. I think all of us are doing the best we can in this situation. But I think it's a very difficult one. I think we lack adequate information. And in a few short weeks, to be quite frank about this, the people, and this came out at the last meeting, I'm not aware of the details on this, but evidently the current city council did not back the situation in terms of trying to push it forward with obtaining the RFPs, which all of our advisors say we need. But there is this current situation where it's, quite frankly, city council might be different in a few short weeks, and then we might have the opportunity to have our RFPs, which everyone has told us that we need. And I hope that maybe some other people, other members of commissions, have comments on this before we go to Mr. Wright. or comments on other matters. It's our opportunity to speak to each other.
If there's no comment, Chef, are you prepared to answer any of the issues that...
Mr. Chairman, can I make one request of Chef on here? In your presentation to us, you have this email. I think I got a copy of it either late Monday afternoon.
Speak into the mic.
Sure, I'm sorry. In your presentation today, can you refer a little bit to this email that you sent to Tammy Bach? And I got a copy of it, I think, late Monday or Tuesday, and a reference to that number 1 at the back. You familiar with that? I'm asking for my own edification.
Yes.
Okay.
Sure.
And in regard to that number, I guess it's exhibit number 1. That's all. If you can address that. Some of the meanings there. Right.
Were you going to open it to public comment first, Peter?
No, because it made more sense to have the data out.
Sure.
And certainly we're opening it up for public comment in order to give you an opportunity to report back on what was your takeaway at the last meeting. And we've gotten several communiques on that, but would open it up so that both commissions can have a dialogue regarding what the status of the contract is now, and as I had mentioned at the last meeting, the concept of a best and final offer, and does that apply, if you will,
before Mr. Wright goes forward, let me reply to Laura a little bit. We got a letter from OUC. We did not get a lawsuit. We got a letter. Now, the fact is, it was a pretty effective letter. And I think Mr. O'Connor has specifically said, and I think it's true, the newspapers did say so, that many of the people that would have bid on the project backed away. Now, it isn't OUC's fault that they were cowards and backed away. Their letter worked, and the art of war is to settle a war as quickly as you can, and if you need to threaten a guy, then threaten him, get out of the war. And our city council, our elected officials, under advice, decided it was not timely for them to get involved in another lawsuit. So it certainly, OUC contributed to the problem, but it is certainly our elected officials who walked away from going forward. Had they been bold enough and stood up, we probably would have gotten some of the offers. But to say it's OUC's fault when our elected officials made the decision not to go forward, it seems to me changes where the issues lie. Now it is true that we can stall and try to throw the burden on maybe a potential new elected official, which would mean to me that we are going to start over in our research and bring them up to speed. And I'm not a lawyer, so your other paragraph, I'm not sure what that means. I don't know how any lawyer would defend it. And all I can see is more and more legal fees coming out of these issues. And in the meantime, the ratepayers continue to pay the bills. And we're still in a OUC contract that we have to live with, period, for the next 16 years. We have an opportunity to do something better for our ratepayers. It's not perfect, but look, politics is not meant to be perfect. It's meant to achieve the possibilities. We're not going to get to utopia, I don't think. And I just cannot foresee this city council taking on another big legal fight at this point in time, given the magnitude of its other legal problems. unless I'm wrong, I don't see much in these arguments about who's done what and that we are where we are.
No, just fundamentally, we're going forward without due diligence as defined by our own consultants and even by Mr. Wright.
Well, again,
which is just a really bad situation. I mean, to go forward without due diligence is that's indefensible in itself.
But I would agree, and I did my own analysis, forgetting all of what Mr. Wright did. I did it myself, and it's clear to me that if you compare the OUC contract that we have today, forward 8 years, against the OUC contract they're giving us, proposing to us, it's clear our ratepayers are benefiting, no doubt. Now, whether they're benefiting, whether the whole city is benefiting over that period, throwing in some other things, it's not quite clear. It's clear from the figures that OUC did bluff us out of probably a $22 million gain if we'd gone all the way to the market. But the reality is we really didn't know we were going to get to that total market. That was just a guess. We might have gotten there. We might have gotten close to it. But it looks like to me that the difference between where we are today and where the market would be, OUC split it with us, just about split it. There was a potential $90 million gain. We got about 60 of it, which is pretty good. Now, they did get the gas transmission, but I have to live with our consultants who give us not much value to that gas transmission.
Yeah, I tend to doubt that myself.
See, again, when I look,
I wouldn't speculate on commodities.
Yeah, I don't know either. But looking at it, I sort of think that again, it comes down to the fact, either we trust our consultants or we don't trust our consultants. If we don't trust our consultants, then the hell with it.
I do trust them.
We'll start over. That's what it comes down to.
I do. That's why I wanted due diligence. That was their recommendation, and we do have to assign a value to that gas transportation because, as you know, in the existing contract it reverts back to Vero Beach, and in this proposed amended contract, they keep it permanently or in perpetuity. So we certainly need to know what we're giving away as best we can. And yes, I understand it's difficult to know, especially because we can't get spreadsheets, we can't get a lot of things. We have a lot of missing pieces. I guess this is a scenario of moving parts and missing pieces.
But if they didn't
colliding,
have to negotiate with us, we do have a $50 million net present value on the table. There is value to the gas. It is in the $50 million. It is in the $60 million. They priced it in. I mean, that's the name of it. They didn't break it out and say, okay, 10 of the 60 is the gas. It's lumped in. So to say we didn't get paid for it is silly. We did get paid for it. So,
well, I didn't,
at least in my opinion.
Yeah, I didn't say we didn't get paid for it, but we'll be looking at that number today, presumably.
Yeah.
Glenn, where does our ratepayers benefit under this proposed? You're saying our ratepayers will benefit under the proposed new contract with OUC?
Dan, I sent you an analysis of the OUC contract today and an OUC contract proposed. Clearly, Dan.
I didn't get it. So
but it's in your email. But
okay, just saying, where do they benefit? Tell me now.
Dan, you should have it, but it's
okay.
There is a $60 million gain over the next 8 years, without any doubt about it, Dan. And I ran the numbers, and I didn't have the access to the Excel, so I took it right off of Mr. Wright's proposals. And I took today's deal, the proposed deal, and the market deal. And clearly, Mr. Wright is correct. In the 8 years forward, we do save about $60 million.
Okay.
Nominal. About $51 million net present value. That's just clear as mud in the paperwork. Now,
I think you could very well be right, too.
If that's not true, then the figures aren't true.
Well, the figures that I have from Mr. Wright don't say that. That's all I'm saying, Glenn.
Yeah.
Well, and let me just point out, you said it was $60 million in 8 years.
8 years.
Correct.
Correct.
And then they're not, between now and 29, being locked in to a contract, which people have admitted there's improvement in some of the language, whether it's the force majeure and others that have been discussed and returned on. So the critical path is we can go to market in 8 years, not in 2029, which is a crucial advantage rather than have OUC walk away and say, well, we'll see you again in 2030. Go ahead.
Just briefly, and the shorter term is worth another estimated 67 million NPV to all of our customers.
I agree with you.
In addition to the 51 million over the first 8 years, being able to be in the market based on what we know today and assuming that everything holds still, it's worth another 67 million NPV to be out of the contract at the end of 23.
And I agree with that. I've run the figures myself, and I absolutely agree with that. There's no doubt. There's more risk in that back 6 years.
Sure.
But in today's market, we're clearly ahead of the game, and who knows where it's going to be 6, 8 years from. But based on the data we have, no question about it, our clients, our ratepayers are better off. No doubt.
Assuming the numbers are right.
Assuming the numbers, and that's all we can do.
And that's all we wanted to do was vet the numbers.
Yeah, but the only thing I can say to that, Bob, is that it's still the correctness of our valuation is going to be the projection of the gas cost 16 years out, 15 years out, 8 years out. And those aren't going to change. So it's a mathematical equation. The only thing we're going to really analyze is this mathematical equation correct? And I have blown contracts because I didn't do exactly what you said, analyze every little figure in there to make sure the math is hitting the right places. And I understand that. I do. But if I have to assume Mr. Wright's used Mr. Harrington a long time, and I have to assume that looking at that history, that they have a darn good record of being successful on their deals. Otherwise, I got to start over with a new staff, a new group.
Well, I think having another set of eyes like we could have done would make a difference.
Bob, I don't disagree with
we
that.
all bring different skills here.
Yes. Yeah, I understand where you're coming from.
I'd hate to have to recess this and convene again tomorrow morning, but go ahead, Chef.
So would I, Mr. Chairman. Thank you. If you need me, I will be here, but I was rather hoping to be home at my farm tonight. Thanks. Okay. Just to respond briefly to a couple of things, particularly comments made by Commissioner Moss. Vitiation can lead to rescission under extraordinary circumstances. The economic changes that occurred here are not extraordinary circumstances, in my opinion, that would give rise to the city's ability to seek and obtain rescission of this contract because of changed circumstances. A contract, as my law professor used to say, a contract is an allocation of risk. And he was quoting his law professor. A contract is an allocation of risk. We took risks. OUC took risks. Gas could have stayed at $14. It didn't. That's what the fact that gas fell through the floor and stayed there with shale gas and everything else that's gone on in the world economy and in the energy market is why we are where we are. If gas had stayed at $14, I'm not here. I'm off doing something else.
So we've been paying much more than it's worth almost since the contract began. I think you're on record.
That's a true
actually
statement.
In these minutes. You said it yourself.
Yeah. That's true.
It's been unreasonably high rates for many years now.
I don't like my mortgage rate, but that doesn't mean I can call the bank and say I want a lower one and demand it.
It's generally, I think, business, not personal.
And the analogy to that Mr. Chairman, is we called OUC, Analog the bank, and said, can we get a better rate? And they didn't have to, but they said, yes, we will happily work with you. We'll also work with you to do a refi to a shorter term. But I don't see any grounds for a suit for rescission here. This contract allocated risks both ways. OUC took risks that the contract could have been underwater in their direction. We took risks that the contract would be underwater in our direction. We are not unable to perform this contract. We've been performing it for nearly 6 years, since January 1st of 2010. We are not unable to perform.
No, I didn't say we were unable to
But
perform.
when you quoted whatever doctrine it was or whatever citation you were quoting regarding vitiation, you made the specific remark that when a party is unable to perform, vitiation to lead to rescission may apply. We are not unable to perform.
Mm-hmm.
And the other thing I wanted to remark on is the due diligence such as we might have obtained through RFPs. We have really good due diligence. It's not final bid in hand due diligence verification. But Bill Harrington has been working in energy in Florida for 40 years. He is the bulk power supply consultant for a number of municipal utilities. He is as well informed, possibly better informed, as well informed as anyone, possibly better informed than any individual in the power supply market. He knows what the bids are. His information that went into his market estimates is based on what he knows about very recent bids. That is really good due diligence, in my opinion. You know, and as terms of
yes, and as I recall, the go-to-market scenario was the best one. He advised that. That's in the minutes too from June.
Yes, and we, as I said on whenever it was, either Monday or last week or possibly both, I misestimated OUC's response to our go-to-market.
Well, that's right. It was your recommendation. We voted unanimously. Both commissions voted unanimously. City Council voted. I don't know that was unanimous, but they voted for the RFPs. I think that's a huge loss to us. With all due respect to Mr. Harrington, and Mr. Harrington recommended go-to-market.
Yes, I will add. We did get an extra $7 million, plus or minus $6 or $7 million of additional concessions from OUC in the final deal. We went from a net delta between the go-to-market and the OUC PPA of around whatever it was, $20 to $23 million, depending on the assumptions, down to $16.3 million. If you weigh that, and this is what I told Council in August that they voted on, if you weigh that against the risks of delay, if we keep Big Blue operating, we're paying more. If we shut Big Blue down, under the existing contract, we're paying even more because that would shift the purchase to a base purchase instead of keeping Big Blue running. That's costs. There are foregone savings of what we lose here. There are litigation costs, not to mention the train wreck of being in a lawsuit with a sister utility. That's worth something. It's hard to put a dollar value on it, but all in all, it's my judgment and my recommendation that the Council adopted on August the 18th that with the additional concessions from OUC, the risks of delay, the additional potential costs of delay outweighed the potential value of continuing with the RFP process. That's where we are.
Mr. Wright.
Yes, sir.
You mentioned that if we shut down the power plant, it would cost even more.
Under the existing PPA.
Under the existing PPA.
To be clear, yes, sir.
And at the end of our meeting on Monday, I became aware that we have plans I knew we had plans to shut down the power plant, but I spoke to Mr. O'Connor afterwards, and he said that we had basically reached a point of no return on the going forward to shut down the plant, and the plant will be shut down on December the 1st. So on December, for the month of December, if we don't sign this contract now, or if we don't sign this contract before the December, or we will be paying for 54 megawatts under the base case scenario. Is that correct?
That requires an interpretation of the contract, and I apologize. This is going to sound like lawyer weasel, but I'm not sure whether that's exactly right. I think that the way the contract works is each year going into the next year, we set a billing demand for the next year. That billing demand is based on starting with our peak demand, our projected peak demand, adding 15% reserves, subtracting the FUMPA entitlement capacity of 52 megawatts, and then under current conditions, subtracting the Big Blue capacity of 54 megawatts. Whatever that difference is, yields our billing demand for the next year.
Is that a calendar year or a fiscal year?
And under the OUC contract, it's a calendar year.
So if I were to restate my question and say January 1st, could you give me a clear answer?
No, and I'm going to try to explain where I think this falls out. If we go ahead and shut Big Blue down, I would say I think OUC would probably be within its rights under the contract to say, hey guys, your Vero CC capacity, defined term in the existing PPA, has now gone to zero. Therefore, your billing demand is now increased by 54 megawatts. That's a live possibility. The reason I hesitate to say that is the absolute positive result is that, believe it or not, we do have good communications with them, and with everything that's going on, they might not assert that right instantly to be effective January 1st. I think they'd be within their rights to do it, but I can't tell you for sure that they would.
All right. If we were to,
if they did, it would cost us 54 times 13,760, which is a bunch per month, which is a bunch of money.
Yes. If we were to pursue going to market, how would you evaluate their response on January 1st?
I think they would assert the right that I suggest that they have. I think they would say, your billing demand is now 149 megawatts, because they wouldn't be giving us the 10 megawatt reduction under the new PPA. They'd say it's 95 plus 54.
Okay. And that would cost us $8.9 million per year for the 54 under the existing contract, the 2008 contract.
In 16, that would be the number. It'd be
16,
a bit higher in 17, a bit higher in 18. I think it maxes in 19.
Maxes in 18.
18, 14,950. Okay, thanks.
So next year it would be $8.9 million.
Yes, sir.
Which we're budgeted $6 million approximately for the plant. That would cost us an additional $250,000 per month.
That's correct arithmetic. Yes, sir.
At other times, our cost of operation, that includes capital, is $4 million. Or has been historically running about $4 million.
The fixed O&M runs about $4 million plus the.
And so that increase, so the increase would be somewhere between $250,000 and $400,000 a month, depending on how we manage our capital improvements. I think this is an important piece of information that I just developed as the meeting closed, and I do have some questions about this decision to go ahead and close the power plant without having a decision whether we're going to replace the contract or go to market. And I don't recall the Utility Commission making that recommendation. And I don't recall, and there may have been a directive from finance to the staff, or a blessing of the staff's plan, because it's the staff's plan by finance. I don't believe it's been done by utilities, and I'm not sure that the city council has, directed the Jim and the staff to make this decision. And so I guess that's a question for Jim. What was the decision tree to pick the December 1st date?
The transmission study, which is what gave us the timeline and the date. We started the transmission study with the understanding if there were major upgrades that are going to be necessary, it would put it off for several months. That came back as not the facts. So the December 1st is set by the transmission study as the capability of closing Big Blue. I think in the general conversations we've had with both the Utility Commission, the Finance Commission, and the City Council, is the city should not be in the generation business, and so therefore our direction was, again, implied. I'm like you, I don't recall a formal vote, but the implication was that we would get out of the generation and close the power plant. I don't recall anyone ever saying, keep the power plant operational. I may be wrong, and it may be, but the fact is that we created the transmission study predicated on the fact that we were going to close the power plant.
Well, we've always been moving towards closing the plant, but I also don't recall anyone explaining that it would cost between $250,000 and $400,000 a month to close the plant under the current contract.
Under the current contract. Yes.
Under the current contract.
But in the same time we were doing the transmission study, we were trying to show where we could actually reduce those costs, and that's what we were doing, and that's the plan in front of you. If there's anybody in the room that wants to stay in the power generation business, we'll make that recommendation to the City Council and move forward with that, and then the Council can take its vote. In my opinion, and again, this is just in the operation of this facility, you have two risks. One is the personnel risk, to make sure you have the adequate number and train people on the job at all times. As you've known, for the last 4 years, we've been going through the transition of trying to figure out if we're going to sell the system, and i.e. the power plant would be closed. There was a very dedicated time in the contract for the plant to be closed. So retention of employees, we're down below the minimum right now, predicated on the fact that we didn't want to hire new employees, take on additional risk as to the closing of the plant. So that's the one issue. The other is the capital. All of you folks have been sitting through here when we spent millions of dollars when that plant goes down, because we are required to do that. So the risk of the average expenditure is $6 million is a nice average to have, but next year it could be $10 million. And so, in my opinion, you do a risk avoidance and try to do the risk avoidance, and that's what this whole plan is predicated on, is that risk avoidance. You have a contract, an amended contract in front of you that reduces our risk term by reducing the term of the contract, and it also gives us the ability to get out of the power generation business at an affordable price. If we decide that we don't like this contract for some reason, I guess when we say we're beyond that term, we're never beyond the term. I mean, as long as we have somebody at the power plant, I'm just telling you that we've gone pretty far down this road. We've sent the message to the employees. We've sent the message to the union that represents those employees, and it's pretty far down there. But if the city thinks it can save $200,000 a month, then we can keep the plant open. But it's a very risky condition. I don't think there's anybody in this room that believes that those generators are the most modern and the most up-to-date and the most well-maintained generators in this country, because they are not. And we, again, when we started the sale, we signed the contract for the sale of the utilities, everybody knew that there was we anticipated that there was going to be a very short life term of that facility. And that's the plan that we have instituted going forward. I will say that if we reject this contract, amended contract, which is, again, that's the right of the city to do, we're going to be in the power generation business if we want to save that $200,000 a month for a pretty long term, so we might as well get ourselves braced for what it's going to take to maintain the power generation. So it is part of the equation. There's no question about it.
Okay, so if we were to need a little bit more time.
There is no such thing, Scott, as a little more time. There is no such thing as a little more time. The fact of the matter is, we've been talking about this for over 4 years that I've been here, and you guys have been talking about it a whole lot longer than that. And I can go back and show where John Little was involved in the same type of discussion. And that's a long time ago. So saying that we're going to put it off for a couple of months, you can't do that. I've got to go hire employees tomorrow.
Okay. So, all right. Well, that's
just to give you the supplement.
I didn't think there was a little bit more time when I came in this morning, and I thought you gave that impression. So we're pretty much irrevocable decision to close the plant December 1st.
Again, nothing's irrevocable. There's been no one given layoff papers.
All right.
So,
but pretty far down that path.
We're very far down the path. And we have a transmission study that says that we can get power to support our native load here. And so we are very, very far down the path.
Thank you.
Thank you, Scott. That was very sobering.
Thank you, Mark.
Let's go.
Okay. I would like to start. I mean, I'll do this however y'all want to do it. You're the client. I would propose to start with follow up on my further discussions with OUC, and then maybe from there I'll answer Mr. Stump's question about the email that I sent earlier in the week, responding to a request from Councilmember Turner. And then I'll move on to the side-by-side comparison, which includes some additional information. The side-by-side comparison was also in response to a request from Councilmember Turner, but there's some additional information there responsive to requests from these commissions. Okay. On Monday, y'all asked me to go to OUC and ask that they agree to share litigation costs in the event that we get into litigation under the change in law provision, that OUC agree to reduce the scope of events that would give rise to our right to invoke the provisions of the change in law, section 1511.2, and that OUC reconsider the term of the provisions in the PPA that would give them permanent release of our gas transportation capacity. So I did that. I did, by the way, since there was also discussion about a recent purchase that OUC made of some FTS2 capacity on the FGT system that they effectively bought from or through NRG. I also inquired about that, and my memorandum reports on that as well. To respond in order, OUC is not agreeable to sharing litigation costs. OUC would be agreeable to deleting the references to federal actions, but not to state legislative action. And I go on to discuss this and with my further recommendations. Perhaps I should have been able to think this through on my feet on Monday, but I didn't. And having had 3 days to think it through more fully, I will tell you it would be my advice, and it is my advice and recommendation, that we drop any request to reduce the scope of events that give rise to our rights and our obligation to litigate pursuant to the change in law provision under Section 1511.2. Again, in the simplest terms, this provision is in there to protect us, the city, in the event of a change in law that dramatically impacts our ability to perform under the contract. the new contract. The risk to the city is, if without this provision, if we were to sustain a dramatic adverse judicial or legislative or administrative action pursuant to law, we would potentially be on the hook to keep paying for 54 megawatts of peaking capacity and to keep paying for the minimum demand provision, the 85 megawatts of base product under the new PPA. This is our out provision from that. The minimum floor is a big value of some sort, and I'll talk about that more later, I'm sure. It's one of the main value considerations to OUC in the new contract. They get some protection that our load's not going to go away, or our purchases from them are not going to go away, and it's part of the consideration that they asked for in return for the lower pricing that they have given us and offered to us in the new PPA. The reason I recommend that we not reduce the scope is this. If nothing happens, if we don't have any such event, then there's no issue. We don't incur any litigation costs, and we don't ever have to invoke the capacity purchase reduction provisions in the event that our litigation is unsuccessful. If something dramatic and adverse does happen, yes, with OUC's declining our request to share the litigation costs, we're on the hook to litigate all meritorious issues. That could be expensive. I mean, it could be a couple $1 million, depending on your attorneys and exactly what it is. It could be less. It could be more. It could be $2, $3, $4 million. Hypothetically, I have a hard time imagining it being that much, but hypothetically, it could be. But the countervailing consideration to that is that if we lose, if our ultimate challenges are unsuccessful, say, hypothetically, we go to the Florida Supreme Court and lose, and we file a petition for writ of cert to the United States Supreme Court, and they take it and we lose, which I have a hard time seeing, but if you went all the way and we lose, if we don't have the protection of being able to invoke 1511.2, if we didn't have that, we'd be on the hook to keep paying for 54 megawatts of peaking capacity and 85 megawatts of base capacity. If we lose with this provision, we get to shed load, starting with the peaking capacity. Naturally enough, from OUC's perspective, they'd rather have us reduce our purchases of the lower price capacity first, which is not trivial. It's a lot of money. It's a couple $1 million a year. And then if we lose more than 54 megawatts and we start eating into the base product, then we can reduce down to that level which is necessary to serve our load, including reserves. If it falls below 75, we do revert to the demand charges under the old contract, but think about what that does for us. It puts us back where we would be today. So in my opinion, the risk, I think ultimately in stepping back, the risk of this happening I don't think is high. But if it were to happen, the economic risk to the city is much greater than litigation costs, which is why I recommend that we don't pursue further changes to 1511.2.
Okay, well, how does this sentence in that section come into play then? It says, if the parties are unable within 60 days following the beginning of such discussions to agree upon modifications as first amended agreement that would restore the fundamental economic bargain agreed to by the parties herein, otherwise be mutually acceptable to both parties, then Vero Beach shall no longer be entitled to a 10-megawatt reduction in the forecast under Exhibit C. As I read that, they can say, oh, we don't like it. You don't get the 10-megawatt reduction. That seems kind of one-sided. Am I reading that wrong? Or?
No, I think you're reading that right.
Okay. All right. Well,
but that only applies to the 15-megawatt reduction, and the first part of that is, I think, naturally enough, it's a provision I try to put in every agreement I work on, that if something weird happens, that the parties will try to negotiate in good faith, franchise agreements, PPAs, et cetera, that I negotiate. The party will try to renegotiate a deal that works out without having to litigate, without having to do anything else. So, but if we're not successful at that, then we don't get to knock the 10 megawatts off the peak demand for purposes of computing our billing demand. That would have an economic impact to us in that scenario.
Okay.
And finally, as I said, they had previously told us that the gas transportation was a significant component of the economic consideration to OUC of the deal, and that they were not willing to let that go. I did talk to them about the quote purchase, of the NRG capacity. They bought the capacity, the FTS2 capacity previously owned by NRG, at the maximum tariff rate. They bought it as a present and future gas transportation portfolio management opportunity. They have, I don't know, they've got at least 2 gas units. They're almost certainly going to have additional gas-fired units on their system starting sometime in the 20s, depending on load growth and potential impacts of the Clean Power Plan. But having additional gas transportation capacity has some value to them. The NRG, they bought at the tariff rate. They didn't pay a premium. NRG didn't make any money. They basically NRG got relieved of the liability. OUC took the liability to pay for the gas transportation capacity.
But the NRG rate may have been in market rates already, so there would have been no premium to pay.
No, it was at the maximum tariff rate. And the current market rate for new capacity is higher than 72 cents a million. Now, again, and I said this before, there is some value to the city of potentially retaining the rights. That the economic value, in my view, and this is consistent with the methodology that PA Consulting used when they looked at it 3 years ago, is the hypothetical, the projected difference between the market rate for new capacity that a potential IPP or other utility power supplier might have to go get in order to be able to serve our load, say as of January 1, 2024 or January 1, 2030, if we were referring to the existing PPA. It's the difference between the cost of alternate capacity and the cost of our FGT capacity. There is some value there. The actual value depends obviously on the timing, and it depends on the supplier. The bidders might already have their own gas capacity. If it's FPL, they got a bunch of gas capacity. They will have their own pipeline pretty soon, or one in which they are a significant partner, Sable Trail. So there's a question. PA Consulting said they estimated the value starting as of 2012 and continuing to 2030 was between $5 and $10.8 million, depending on the discount rate of the potential acquirer of the capacity. The $5 million was with a higher discount rate, e.g. FPL. The $10.8 million was OUC specifically, as they articulated in their report. All I can say is I don't have those seem like reasonable numbers to me. You could try to redo them based on future conditions, but regardless, in the best case relative to the new PPA, which arguably isn't the point of reference because we're in the existing PPA, but even in the new PPA, it's whatever value it would have starting as of 1/1/24 if we were to renegotiate or to negotiate with a new supplier. I can't see it being more than $5 or $10 million. And when you compare that to the value that flows to us, the city, and our customers under the new PPA, it's less than 10% NPV.
When could we monetize it if we stay in the existing contract to our advantage?
Well, potentially you could monetize it in the form of a potentially lower bid from an alternate power supplier for power supplies to kick in January 1st, 2030.
Thank you.
Unless we were to option to go to market, in which case we would retain it. We would, if we canceled the contract, paid the $50 million penalty, and then went to market, we would retain that gas contract, and we would be able to use that.
Correct.
Now.
Upon termination of the contract, however that were to occur, upon termination of the existing agreement, the FGT contracts would revert to us.
Okay. So if we stay in the contract, it's 2030. If we
Correct.
But if we did terminate, it would come back now.
Well, it would come back at termination, just to be clear.
If we were to terminate the amended contract, are there any changes in the termination provisions?
Existing contract, don't you terminate?
No, I think
No.
you're asking.
I'm asking, I have a contract full
Hang on.
of red sections here, and
Under the new PPA, OUC would keep the gas contracts at termination of the new PPA, however that occurred. Under the new PPA, the potential termination pursuant to Article 12 is gone. So because they did agree previously to delete the site option, the site lease option, and bear with me.
And that would only be the termination if they wanted to exercise the lease and we could not agree to it, which would require a referendum.
Right.
Then they would have the option to terminate. So, and Section 12 did, just so that I make sure I understand, if they needed to build additional generation facilities on our property to meet our need and any other need, they had the option to do that.
They had the option to lease the site for that purpose, correct.
Okay. And that's the only, that's the only part about that termination that changed.
Yeah, it's gone. Okay.
Yes,
Now, bear with me. I'm sorry. Go ahead.
No, I was just going to say, section under remedies 8.3F about the damages that doesn't appear to have changed, other than just simply says first amended. So, damages shall not exceed the following, the $20 million and then the two $50 million figures. And I think that's just important to remember, that those damages are not liquidated damages. Each party has to prove those damage numbers, and I think that's gotten out in the press or in discussions, that's an automatic number. It's not an automatic number. It's not liquidated damages.
Correct. And under the new PPA, since the demand charges, which would be if we were to default, OUC's damages would, in our view of the world, would it be the difference between the contract price for capacity and the market price for capacity.
Right.
Under the new PPA, with the demand charges being substantially less than under the existing PPA, the damages are much less.
Makes sense.
I mean, obviously, the difference between 13,760 minus market and 10,978 minus market is it's $3,000 a megawatt a month, basically. Which simply means it's less likely that OUC would actually hit the cap of $50 million in that scenario. Scott, I'm trying to continue answering your question about termination. Hang on, sorry. Okay, hang on. Sorry, I'm smiling because of the relationships of exhibits, appendices, attachments, etc. In this. So I'm working on.
I know it's
working
really
on this.
convenient that you redlined section 12 in blue, so I could see that change. But I don't think that was consistently followed because in section 3.2 of Exhibit C, the changes from a week ago were still in red. So.
Okay. I don't know how my computer version talks to Tammy's computer version, but in mine, the old is all in. Actually, that's not even true. The old is mostly in green. The three changes that OUC agreed to previously were in red on my version, but we know what they are, I think. But
yeah.
let's try to keep on track talking about the termination here. Under section 5.2C, Romanet 1, in the event that there's a cost change sufficient to invoke OUC's right to increase its charges to us pursuant to Exhibit C, Appendix B, Section 1A, Vero Beach has the right to terminate. OUC is not allowed to make any such adjustment solely to take advantage of market opportunities, and any adjustment they might make is limited to the amount of revenue required to bring OUC's retail customers to a neutral cost position for the remaining term of the new agreement. And OUC's right to terminate pursuant to 12.2 is gone. And then the other provisions relating to termination are in Article 8, which relate to termination upon default by one part, determination by a non-defaulting party due to a default by the other party. And there are both events of default by OUC and events of default by Vero Beach. And those are spelled out in Article 8, which blessedly has largely not changed from the original PPA, other than incorporating references to the first amended agreement.
Okay. And where does it state that the transfer of the gas contract would survive termination?
I'm pretty sure it's in Article 2 or 3, Scott. 2. New Article 2. At the very end, it says the right title, obligations, and interest in the gas transportation capacity under the gas transportation contracts shall remain with and be permanently released to OUC.
These rights are being assigned to OUC. Is there any scenario that beyond the termination of this contract, they will continue to get benefit, but if it becomes a situation where there isn't a benefit to them, some costs could come back to us because we don't...
No, ma'am. No, it clearly says right title, obligations, and interest in the gas transportation capacity under the contracts shall remain with OUC. Once they take it, it's theirs.
Okay, that's been approved by the other side. Whomever we have gotten these rights, they are approving our assignment of these to OUC.
FGT has to approve the assignment.
Have they done that?
They have done it with respect to the temporary transfer that is now in place, the temporary release, which is now in place from January 1, 2010, presently through December 31, 2029. That assignment has already been approved. Any other assignment, the permanent assignment, as such as is contemplated by the new PPA, would require a separate approval of the assignment by FGT. I would say it's fairly obvious, since they've already approved this and OUC is a big shipper on their system, that's not going to be an issue.
But it's something we would want, because otherwise they could get the benefits going forward, but if it turns south on them, it could be back in our levy.
No, but that's what. Sorry,
But you are.
I'm telling you that I'm trying.
But no, I think you're saying yes, it needs approval. And
It needs approval by
the
FGT.
original contract through 2030, but not beyond.
Right.
That. And so when will that approval be gotten for beyond 2030?
I would say, as a matter of, I don't think it depends on FGT signing off on it, because of the contract language. It says all of the obligations of Vero Beach under these contracts shall remain with OUC. As a matter of contract between us and OUC, if in this hypothetical Murphy scenario, which is a good thing to ask, I mean, that's what you should do. In this Murphy scenario, where something goes ugly with the assignment, I think as a matter of contract, OUC is still obligated to Vero to keep us whole, because they have contractually agreed with us to take the obligations for that capacity, period.
That could be a lawsuit if they.
Hypothetically, it could be a lawsuit if we get to such future point and OUC says, oh, sorry, FGT, we're not going to pay for this anymore. FGT would look to us as the, hypothetically, it's hard for me to imagine this happening, honestly, but hypothetically, OUC could look to us and say, hey, I'm sorry, I misspoke. FGT could look to Vero Beach and say, we want to get paid. And there are actually outs, periodic outs in any rate case. You can get out anyway, so there could be some overlapping period of time, but you can get out. But FGT could say, Vero Beach, we want to get paid. We would say, OUC. OUC would say, We would say, we're interpleading OUC as a third-party defendant, or we would have an ancillary suit against OUC as a matter of contract between us and OUC, saying, y'all took the obligations under these FGT contracts. It's your responsibility.
But how to avoid that is to get approval of the assignment. So that the other party in this contract agrees that OUC is going to be responsible with no recourse to us.
Well, I'm not. That's true. There already exists an approved assignment by FGT of the release, technically from now till 2029.
But not beyond that.
That's true. I don't know, in the ordinary course of events, in the ordinary course of business, I don't know that they would give approval of that kind of assignment here, because that kind of assignment, that this permanent release only, hang on. I don't know how FGT would view approval of the assignment you contemplate. I think, looking at the first part of Article 2, I think it's possible that they and also knowing the assignment provisions of the FGT contracts, they might go ahead and give that assignment. I will say I don't think this is a material issue.
But circumstances change when farther out into the future you get, so that's allocating risk. I think, well, they have the continuing benefit, but they may be able to give up the risk in the end. Just out and go.
Just thinking it through. The risk, the only reason they would want to do that would be if somehow or other gas transportation capacity in the future, let's say in 2030 or 2024, cost less than the tariff rates, given that the cost of new capacity is higher than that today, you'd have to hypothesize that Florida's reliance on natural gas as a generating fuel would fall through the floor to get to a scenario where the market value of new capacity would fall below these tariff rates. These tariff rates are fairly low, 70 cents plus or minus per million BTU per day.
Well, I'd just like to be aware that any time we give something up, that we don't give away all the benefit and maintain risks, because I think that this whole thing, like you're saying, contracts or allocation of risks, and I'd just like to know what risks we retain that, even if it's not likely, is possible, but it's happened. Because as you're saying, the longer term, the longer the term is of something, the riskier it becomes. So, what I like about this amendment myself is, reducing the term of this contract as being a big benefit to us. But, in the same sense, there may be some things that we are not, that we're giving a longer term on, as far as risk without benefit.
Would you excuse me for 10 seconds?
I just want to.
I'm going to try to get an answer from the head of Florida Gas Utility on this.
Okay, my only point is we're doing a lot of speculation on what's going to happen between now and 2030. We have a lot of hypotheses. We've done a lot of hypotheticals. What we have on the table is a amended contract that has been under negotiation, and we can talk hypothetical and challenge all of the experts, but we can't have, as Jim says, paralysis by analysis. At some point, there's going to have to be made a decision. But continue, Chef.
Thanks. The counterpoise to that, Mr. Chairman, is the old saw that the only bad question is the one not asked. So I'm happy to try to get an answer to Commissioner Barton's question.
I'm not trying to limit any discussion whatsoever. I just making a comment in terms that is why we've been going at 4 hours a clip on these. And if we have to have another meeting, we'll have another meeting if that's what is in the best interest. But there's no point in letting this languish without addressing everything and all that everyone wants to deal with. As I said, that's why we are not interrupting anyone. And please proceed.
One final follow-up on the gas capacity. There was some discussion about the possibility that OUC was going to take our capacity and use it for Fortress. What they contemplate with Fortress, and it's not fully executed yet, is a bridge agreement whereby probably for a year and a half or 2 years they will supply gas to Fortress's LNG facility that is going to be located adjacent to OUC's Indian River power plant site. They cannot use our capacity because our capacity does not have that as an approved delivery point. It'll be their capacity. They're going to supply bundled gas to Fortress, which they're going to liquefy and export. So it's not a transfer of our capacity to Fortress. And furthermore, it's going to be done well before 2024, which is when they would get our capacity anyway, or get the permanent capacity, which they already have anyway. So
Well, they're not using our capacity, but isn't that why they want the gas transportation? Does that apply?
I don't believe
to
so.
that?
No, because the deal with Fortress, they anticipate being a bridge deal from maybe 17 to 19, 16 to 18, something like that. They've already got our capacity, and the permanent release that they've asked for, required as part of their consideration in this deal, that the permanent release, the difference between the existing PPA and today's, is that they would get permanent effective 1/1/24 after their deal with Fortress is done. FGT is going to build a new lateral to Fortress's LNG facility. Once that's done, they'll be taking taking capacity straight from FGT.
Are you saying then that the permanent release does not have to do with Fortress?
Yes, ma'am.
I think one final follow-up question on the change in terminations. I hope I probably have another question later.
Just
but whatever.
only one more.
You are not limited, sir.
No, that was a Monty Python joke. Sorry.
One more question in 27 parts. All right.
Right.
Ooh, you are a lawyer.
Under Article 3, we agree that from the perspective of each party, the obligations here under are a power supply resource obligation entered into to serve all of Vero Beach customers and such have an equal stature to an investment in a generating plant. Now, does that affect rights under the termination clauses? Does that increase the calculations? Does that change anything?
No.
Okay.
As I mentioned, that's really an additional, not finally dispositive, but it's an additional protection for the city as evidence that, as between us, Vero and OUC, we consider this to be the same as a power plant for purposes of any stranded cost determination.
Okay.
It's evidence we could show a court if we wind up in litigation on stranded cost liability.
Okay.
It does not affect termination. Go ahead.
So, other than the transfer of the gas contracts, if we were to terminate this contract in 2016 or 2015, if we terminate the 2008 in 2015, or we terminate the first amended in 2016, the only difference in the termination would be the OUC would retain the gas contracts. That we'd still have the same limitations and penalties. They may be calculated differently. It looks like it would be calculated a little bit to our advantage. Harder for OUC to get to $50 million.
Under the new contract.
Under the new contract. Harder to get to the $50 million. Harder to justify that.
Right.
But that was my question about the stranded cost. Would that factor into that? Make it easier? Or would that calculate back into the... that would not change the termination payment calculation, in your opinion?
No, the stranded cost really relates to us in the event that we wind up in a situation in which we're having to seek stranded cost recovery.
Okay, but it also relates to them because if we recover it, we have to share it.
Correct.
Okay.
And the reason for that is if we're recovering, we presumably be having to pay them something. That would be a component of our stranded costs.
Okay.
Okay. I was going to move on and address Mr. Stump's question, which I understood to be basically, could I walk through the discussion about the estimated monthly savings pursuant to an email that I sent on Tuesday?
Okay.
Yes, sir.
Before you do that, I would just like one question for clarification. Under our existing 2008 contract, which I don't think I've read from first page to end. I've read portions of it a little bit. But in that existing 2008 contract, doesn't the city have a right to terminate that contract for any reason and pay the $50 million termination fee?
No.
Am I right?
No.
Where I'm not?
No.
Do we have a termination right under that existing contract?
The practical answer to the question I think you're trying to ask is no.
Okay.
The technical answer is yes.
Okay. Well, I'm asking it because it's referred to in your number 1 and number 2, what I call exhibits, to the
Right.
Vero Beach bulk power supply analysis, your memo.
Yep.
So That was music to my ears when I went through this, and to me, this is where this whole central issue is, right here.
We have the right to, in the event that they invoke an increased cost provision, the increased cost provision in Exhibit C, Appendix B, Section 1A, we then have a right to terminate. If OUC defaults, we have a right to terminate. We don't have a right to just say we're done. That if we say we're not paying you for power anymore, that's a default and not a termination. Okay?
All right.
Just so that, to clarify, if we default, which is what we envision doing in our go-to-market scenario, was not terminating but actually defaulting on the contract.
Correct.
So that's where we would, and the $50 million penalty came in, which we showed on your spreadsheets, $8 million a year.
Correct.
Okay, so we still retain the rights to default, and the caps and the penalties are the same, except they keep the gas supply contract.
Correct.
Okay.
And then, do you think...
Again, with damages almost certainly being less than that. A shorter term, lower incremental damages.
Okay, and I think that I've often used terminate and default as synonymous.
As we all have, and frankly, the use of termination fee in our spreadsheets was shorthand for that, but it really is a default. It's not. We don't have a unilateral right just to terminate. Dan, go ahead.
So this is where they came back, that is OUC, in their communications in August, saying that if we would go to the market on a request for a proposal, they would sue us because we don't really have that right to terminate. And even though we would pay a $50 million termination fee, we could still be held liable in damages. That's their position?
Not quite.
Okay.
That's part of it. The other part of it was that they asserted that they would consider attempting to hold any counterparty with whom we might execute a new PPA liable for damages on some kind of tortious interference theory. We didn't think much of that, but that was what they claimed in technical terms.
Okay. Well, this is a conclusion that I'm trying to get at, if we can. The way I was hoping I was reading this was if our exposure to liability under alternate case 1 on number 1 is $50 million. If that's our ultimate liability, if that's our cap, I mean, these numbers are clear that we're better off paying that termination fee, canceling the contract, retiring the plant, like they're intending to do anyway, go to contract right now, and we save a lot more than $60 million by doing that.
Yeah,
if I'm reading this right.
That's right.
Okay.
If it were that clean, the estimated NPV difference between what we would save and what we would pay them in the clean case is $16.3 million NPV.
Okay. How does it get cloudy or dirty then?
Litigation, delay.
So they would have to come back and sue us saying that they're entitled to more damages than just $50 million. Is that right?
Right. And we wouldn't get the advantage of the new PPA in however long it took to get, hypothetically, to get a new PPA in place with some other supplier, assuming that we could, and figure out that and shake that all out. That's where it gets cloudy.
Okay. So I'm under the assumption that we can go to market and replace our power contract reasonably soon, but is that not necessarily the case? Okay. All right.
I love adverbs. You know, reasonably soon depends on your definition of reasonably. Well, my guess is, you know, if you mean 6 months, no. If you mean 2 years, probably. You know, by the time it shakes out, you know, there's cloudiness surrounding what kind of bids we would get. There's cloudiness surrounding the willingness of other parties to bid. There's litigation cloudiness, and so it's not necessarily true that we could do it reasonably soon. But you know, it could happen, but that doesn't seem to be the case. I mean, I take that back. That could happen, but it's cloudy. That's what I really should have said.
I think that they clearly have shown a willingness to sue us. Suing us would delay it. And their willingness to sue people that may provide us, or threat to sue people that may provide us with an RFP has made it harder to get an RFP. But if it took 2 years, we would burn up approximately half the savings in paying their additional cost for the 54 megawatts.
And the legal fees.
Plus the legal fees.
So, okay. I think that those are the factors that have changed in my mind, and as I've continued to analyze it. It gets a lot more expensive to stay here trying to go someplace else. Where I was going with asking about the changes in the default penalties, we still have the ability to default on the contract at any time in the future. And so the only difference to us, if we default in the future under the amended agreement, is that we no longer retain the gas contracts, and which would help us to lower the price of an RFP. And that, according to our appraisal of a couple years ago, was $10 million. I don't know that that's, we don't have a more current number. OUC wants it, it's worth something. But we're looking at, again, $250,000 a month, or between $400,000 and $250,000 and $400,000 a month if we have to pay for the 54 megawatts under the existing 2008 contract. And that burns up that savings pretty quick.
Correct.
So we still have the right to default, just we don't have the gas contract.
Plus the loss of what the reduction would be under the new contract, amended contract.
Plus, you've gained the advantage of the shorter timeline to evaluate. Instead of 6, we're down to 8 versus 14.
Which makes it harder for them to get to 50.
Exactly. It's going to be, and the base is smaller, so we're definitely better off. I don't think we've tied up the city council's hands to default going forward, but we have shortened the period of time that they can get hit for evaluation. I think that's right.
And we get to market sooner.
Right. That's the way I see it, too. Mm-hmm.
Mr. Wright, let me ask a question, because we're talking about defaults. And I certainly understand what we're talking about, that so we walk away from this contract and then we ask other folks to provide a quote or a bid for us just after we walked away from one contract. How, in your opinion, how easy will it be to enter into another contract where those individuals are going to use our contract as a vehicle to invest in their companies? How easy would it be, you think, to get a reasonable quote?
There are a couple of countervailing factors at work here, and so here is my response. I think you would get bids. It is more or less a buyer's market right now. The prices might or might not be affected that competing bidders might offer, because each bidder has its own decision calculus that it has to consider. But when any counterparty were to come to the table to negotiate with us a new contract, my prediction with high confidence would be that it would be really, 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 really tight in their favor as a result of our hypothetically defaulting for economic reasons, as we're discussing here.
But if we were successful and walked away with only a $50 million expense, then by having the gas contracts back in our hands, would that long-term effect be a plus or a minus for the city and the ratepayers?
you're really asking me to speculate, but I'll give you the best answer I can. Having the gas transportation rights would be a benefit to the city and our customers. The alternate provisions, as I hypothesize, I think quite reasonably, being a lot tighter, would almost certainly be a detriment to us. They would at best, from our perspective, be risk shifting. They would shift risk from our potential future counterparty to us, such that if economic conditions changed again and we found ourselves in this future contract underwater, we might find ourselves with a $50 million LD, like liquidated damages provision, not a $50 million cap. We might find ourselves with other almost draconian termination provisions insisted upon by another party. Now, I can't say this is speculative.
I
And
understand.
it is what it is. But if part of our job as attorneys is to think about what the other side is thinking about. And if I'm representing a counterparty and this has just happened, I'm going to say, hypothetical future IPP or other utility making a sale here, we need some really rock-solid, irrevocable protections. We might even demand a performance security bond be posted by Vero Beach to ensure their performance. Actually, I get in debates over that a lot, representing independent power producers with utilities. They demand performance bonds. Somebody on the other side of this might demand a performance bond. This is speculation, but it cuts in both directions. But it's there's some potential benefit. There's going to be some additional risk, more difficult to quantify.
Okay, I understand that was a loaded question because it required some speculation, which none of us can really come up with. But we've done a lot of speculating, and I was just curious how you thought it might work out. I made the assumption that we would have a much tighter contract to work with. Thank you.
Additionally, we've agreed to go much shorter terms in any new contracts. I don't think we're going to get into another 20-year contract. That wasn't the plan that was proposed. So I think that would mitigate that a little bit.
That's correct. But before I go on, Mr. Harrington was able to reach the head of Florida Gas Utility, and he's got the answer to Ms. Barton's question.
She asked if there was a permanent release. Florida Gas Transmission, which is regulated by FERC, has no basis to deny that if the delivery points stay the same. I assume the primary delivery point is still Vero Beach, since the plant's still operational. If the delivery points are changed, then Florida Gas Transmission gets to review the operational impact of the change in delivery points. However, generally, since the delivery points would be changing from south to north, he did not think there would be any issue at all. The gas transportation constraints become greater and greater as you go toward Miami from Pensacola. So we'd be moving from Vero to Orlando, and he said could not envision any problem. But they would review it, and they would, if they determine there's an operational issue there, they have the right to not to approve it.
But that's in the scenario where there's a proposed change in delivery point.
Correct.
If there's no change in delivery point,
they have no basis.
The agreements as they stand.
Right.
They have no basis.
That's correct.
Okay. On Tuesday, I sent a memo responding to a request from Councilmember Turner regarding the backup for the estimated savings of $750,000 per month under the New Deal. That number was calculated based on, in August, which is when it first became to be discussed. It was calculated in August based on the estimates that we made at that time of net present value savings to the city and all our customers of $126 million NPV over the 14 years of the New Deal, i.e. over the 14 years of the existing deal, which, 8 years New Deal, 6 years in the market. So it was $126 million divided by 14 is $9 million a year. $9 million a year is $750,000 a month. Naturally, things change from year to year based on whatever conditions are. Following the finalization of this year's budget, we got new information of the cost of Big Blue, which are greater than we thought they had previously thought they were, and it reduced the NPV savings from 126 million to 120 million. So the 119.7, divide that by 14, divide by 12, takes it down to $712,000 a month. If you look at the nominal, based on the updated budget numbers, it's more like $1 million a month. It's $12.2 million a year, average over the whole period. More of that is in the out years, as you know, than in the near term. But for reference, I went ahead and calculated the estimated nominal savings for 16 with everything updated and this significantly higher Big Blue cost than was previously assumed. And we didn't make the numbers up. We had a powwow of all the players, and we agreed the number was $600,000. When the final budget number came down, it turned out to be 2.9. That just happened, and it is what it is. So the savings in 16 is about $317,000 a month. In 17, after Big Blue is shut down, and we're at that point at $832,000 a year, all-in cost, including the pension liability, it's $650,000 a month nominal. In 18, it's $720,000 a month. So in 24, the nominal savings, which is the first year after we're out of the contract, the estimated nominal savings is $1.3 million a month. Do you have any further questions, Commissioner Stump?
Well, in regard to those savings, as they are somewhat discounted, so my question is, do those savings go into the general fund, or are they used at all to reduce the ratepayers' monthly bill? Maybe I should be asking that question to Jim or whoever can answer it.
It goes to the ratepayers. We don't transfer other than what you see in the budget.
Okay.
Yeah, these are reductions in bulk power supply costs, and actually there would be a slight corresponding reduction, 6%, in the general fund transfer as the costs come down. These values are only the reduction in bulk power supply costs. As the total bills go down by, let's just say, $600,000 a month, then the corresponding general fund transfer, as it's going to track through in succeeding budget processes, is also going to decline by 6% of the cost reduction.
So what I hear on the street when people talk about this, how much this new proposed agreement will reduce the monthly bill, I hear $2.50 to $3 a month. So that's where the analysis comes from to justify that conclusion. Do you agree it's about $2.50 to $3 a month?
Our best estimate is it'll be $2.50 in December, on top of the $1.85 that was implemented in September. That $1.85 would be afforded by the change in the PPA. It was the early implementation was afforded by the fact that we had better sales and thereby more revenues than we expected in the previous year. For 17, the reduction is expected to be, well, depending on how you look at it, the reduction from, hang on, I got that going. The reduction from, as compared to what the rates would be under the existing PPA in 17 is $10.80, in 18 it's $11.88,
okay,
and so on.
So
each $1 million reduction in cost is equivalent to perhaps
$1.30.
$1.30 in
Yes,
rates. Recognize that all of these litigation costs are charged to the ratepayers. So at $1 million, it's worth about $1.30 more that ratepayers are paying for all of our litigation costs.
Yeah, and the reason the reduction is, to be blunt and candid, as I always try to be, the reduction in December is a lot less than we wanted it to be. Compared to the existing PPA, it's $4.35. $1.85 of that's already been implemented. But the reason it's not more is that the estimates of keeping Big Blue running increased a lot. Increased $2.3 million versus what we were assuming, which is another $3. We're all right at. So And then, like I said, the comparison to the existing PPA moving forward into 17, 18, and so on is a lot greater.
And if my assumption is correct on the change of closing down Big Blue, staying under 2008 pricing for the 54 megawatts of peaking, and Peter's numbers are correct, come January 1st, we're having pressures to put upon us to raise rates $3.90 or $4. So if every $1 million down is $1.30, we're looking at almost $3 million up come January 1st. Now they may not charge us that if we decide to go to market and decide to fight them, then they most likely will. So this is another factor. And I don't see, other than the gas contracts, we still have the same rights to terminate or to default on this contract going forward if we can develop different information. And their termination payments or the default payment would be some calculated number less.
Before I move on, I wanted to address a question from Chairman Gorey early on. The proposed PPA that you have, with the changes they agreed to pursuant to my previous requests, is the best and final offer. It's definitely the best and final offer on economic considerations. Somebody could find some term or some wording change that we could still fix as things stand. But the economic guts of this deal is a best and final offer. As I said this last time, this is the deal we agreed to. Their CEO, their vice president and general counsel, their vice president of their business unit, the mayor, Mr. O'Connor, and I agreed to in terms of recommending to our constituencies, you all in council, they to their board. That's the economic deal we agreed to. It's the best and final. It is the best and final offer. I observe that Mr. Wilson is standing behind me, and if he'd like to talk about what we've already talked about, that is fine with me, and then I can change gears and talk about the side-by-side comparison of cost and benefits, which is a different document that I distributed yesterday, if that suits you, Mr. Chairman.
Oh, thank you, Mr. Wright. Mr. Wilson?
Charlie Wilson, Post Office Box 65114 in Vero Beach, because I still don't want Mark Schuman to know where I live. Reminds me of a poem. The time has come, the walrus said, to speak of many things.
Of shoes and ships and sealing wax, of cabbages and kings.
I want to point out that was just before he ate the oysters. Yes, I want to talk to you as citizens and people, not your positions and boards, and not members of political parties, and not members of special interest groups. But just for a second, I know that all of you are deeply embedded in these numbers, and you've talked about numbers for 8, 9, 10, probably a little over 10 hours, I think, so far. The very first time the word ratepayer was mentioned was about 10 minutes ago by Mr. Stump. Because one of the considerations you have is, as you're deeply involved in all these little numbers, and some of them are big numbers, is what are you doing to the people of this town and this community? When the learned Mr. Wright, and thank you for taking these changes to OUC, and thank you for getting the federal government out of our numbers, so we don't have to fight the federal government. I thank you for that. But what he said is, this is here to protect the city. This is here to protect the city from whom? That particular legal section is here to protect the city from its own people. if you sign this contract, now especially that they have said that it's not, they declined to take out the regulatory. If you sign this contract, you are authorizing the city of Vero Beach to sue and fight its own citizens. If there is a referendum in this town to not allow the city of Vero Beach to be in the utility business, you are telling the city of Vero Beach they must sue to stop that. If there is a statewide voter referendum that affects our contract, you are authorizing the city to fight against that. If the state courts decide that Indian River Shores has a good case, we are now turning over the decision of how far to appeal that to Orlando Utilities. How can you wake up in the day and say it's okay for you to authorize the city to use its might, unlimited money, because you know where that money comes from? The ratepayers you're fighting. Not only are you doing this, and this leads to the Indian River Shores suit. The Indian River Shores suit is based on the fact of bad management practices. And it is based on that litigation is based upon that this council and this city, because you're not just doing this to city residents, you are authorizing the city of Vero Beach to fight county residents, Shores residents, and city residents who happen to also be county residents. Okay? So just the fact that we have asked them and they've sent back to say, nope, we're going to keep you, and nope, we're not going to pay for any of it, what that tells us is that's what they're planning to do. What this is for is you are authorizing, along with all the good things. You know, you've got some rate reductions, you've got some shortening the term, I understand that. But do you know what you're doing to the citizens of this town? You are like a government authorizing another government to tell you to quell the revolt of your citizens. One of my favorite Wizard of Id columns is a guy comes running into the king's anteroom and he says, Sire, the people are revolting. And the king says, yeah, I don't like them either. Well, that's basically what we're doing here. Is you look at the language of that. How can you do that under any circumstance? Under any financial circumstance. And you are being led down this path because you're being led because they know that you want numbers. You're talking about numbers. You're being coerced. I think you're right. You are being coerced into saying, you've got to do this because if not, we're going to close the plant and it's going to cost us millions. You've got to do this. Otherwise, OUC is going to sue us. Well, let me tell you something. The county's going to sue you.
They have.
And the ratepayers are going to sue you. What if you get a class action suit by the ratepayers? The city of Vero Beach going to fight your ratepayers using their money? Okay. So when you're talking numbers, as you all have done now for all these hours, one of the things I'd like to mention is that these are people. These are ratepayers, and just because. It's strange, and people may not know this, and there are special interests in this town, and there are special interests hard at work in this town. I've been provided with a list of 2,114 current members of the Indian River Neighborhood Association, and many of them are sitting in this room today on these boards whose name appear on those lists. Out of those lists, there's I think 200 major donors. There's 51 donors that have given more than $1,000, up to $10,000 to the Indian River Neighborhood Association's political activities. All but one are in the same zip code. All but one. So there is a huge political movement here between the two main decisions we have: utility independence, permanent subsidy of very wealthy people's taxes, property taxes. Those are the two. Those are the two directions we're going. Now, according to, you're talking about the default. Can we? Because you're always, Mr. Gorey, you're always talking about the alternative is to 2029. Alternative is not 2029. It may take us a while. I understand. I understand there are pitfalls, and but the difference between default and the difference between a termination, I can't understand how 2 months ago we were recommended to do default, and now all of a sudden we're recommended that we couldn't possibly do that. We're given all the reasons why you can't default. We have a right to default. We have a right to default under the contract. It's been in there. Okay. So the fact is we are being led to slaughter. Because philosophically, look at what you're doing. It's not just the numbers. Mr. Brabant, you're a brilliant numbers guy. But think about this. Think about what we're doing. Does the government of the city of Vero Beach, under this contract, not only has the right, they have the obligation to fight their own people? I don't see it. I don't see how you could, I don't care what the numbers are. I don't see how philosophically that you can allow to be yourself to be forced into the position where you are fighting your own people. Not since the Vichy French has that been done. Okay. Going to market. Who are the other providers? I want you to look back in history. I'm the one that sat right there when the second place bidder was FP&L. Do you know how FP&L didn't? You know why we're not in a contract with FP&L right now? Charlie Vatunik. Charlie Vatunik, a city employee. Charlie Vatunik was on the search committee, and according to his rankings, he threw the rest of the rankings off by severely depressing the ranking of FP&L, who OUC won by one vote.
What does that have to do with what's before us at the moment?
Well, because what you're doing is you're not only authorizing us to fight OUC, this goes back to the basic premise of FMPA. Because what's happening is we now have to fight anything that gets us out of FMPA. According to the meeting yesterday with the Taxpayers Association, Mayor Richard Winger said, we don't think that there's anything that we can do here locally. The only way we're going to get this done is through legislation, which I support. This contract removes that option. So how many options?
I don't believe that's the case.
If Orlando Utilities says that a referendum passed by the people of Florida or a law passed by the Florida legislature, if they say, Vero Beach, you must fight the constitutionality of that, we have to fight the constitutionality of that.
I think if it's targeted specifically to FMPA only, I would take a different stance.
I opposed, let me tell you this, I opposed the 2008 contract. I was right. Okay.
But now you support it.
What?
You obviously support it if you want us to go to...
Mr. Gorey, what I would probably support is going to market. But the reason I opposed the 2008 contract is because it would bring us precisely here. Okay? Precisely here. Everybody knows it was a bad contract now, but there weren't very many of us that knew then. And we were fighting the same battle with the same people with the same political backing that we're fighting today. Now, I know full well that y'all are going to go forward with this contract because you're going to go forward with any contract. And perhaps maybe this is okay because we're only giving our rights away for 8 years. You know, we're only required to fight the rest of the world for 8 years that OUC's involved. But if our solution is legislative, or if our solution is by vote of the people, you're removing that solution. You're removing that option, and it's the final option. At least for 8 years, you're removing it. So, because after Monday, when they vote for this, and there's 4 members of the IRNA that are on the city council, and after Monday, when they vote for this, there's nothing that we're going to be able to do for the foreseeable future. We might as well all go be farmers. Okay. So all I can tell you is I cannot believe, I don't know how you wake up authorizing this particular this particular legal requirement of the city of Vero Beach. I don't know how you face yourself in the mirror in the morning.
Mr. Chairman?
Mr. Chairman, I just want to say something. I have to be at a meeting at noon, and I have to leave for it. So can I ask a question? Could you take a vote of this commission here, joint? Do we want to vote today or soon, or do we want to postpone? Are we able to do that? Are we at a position in our discussions to do that, or what?
I think we are. Personally, I certainly am, Dan.
Okay. Well,
I think there's one major item maybe we could go to that next is we had a requirement of take or pay of 85 megawatts. Now I see a graph or a table. I guess you can go through it, Mr. Wright. I don't think it addresses what I asked, but let's walk through it and see if it does. With its impacts on Vero Beach capacity charges, if billing demand falls below minimum demand of 85 megawatt estimates for 2018.
I'm with you, Mr. Atwater. I feel that I should respond to three things that Mr. Wilson addressed briefly. He remarked about a statewide voter referendum.
I got to go.
Such a referendum would presumably be one that authorized retail choice for power supplier. Every state that I'm aware of that has adopted retail choice has provided for stranded cost recovery. 1511-2 provides for us to litigate for stranded cost recovery. If the law itself provides for stranded cost recovery, we'll get in line with the other 54 retail serving utilities and seek whatever stranded cost recovery we're entitled to. He made a remark about the possibility of this preventing us from or requiring us to litigate getting out of FMPA. This only obligates us to litigate something that adversely affects our ability to perform our obligations to OUC under the OUC agreement. FMPA is a separate stranded cost item. And finally, OUC did agree that we could delete the federal action requirement there. It's my advice that you not do so, but that's your call. And I explained that in the other memo. So now I'll turn to Mr. Atwater's question. And Mr. Atwater, I'm sorry if this isn't what you wanted. I'm happy to work with you to get it, but I thought it was.
Yeah, I guess what I was asking for is, and maybe it's in this adjusted capacity charge rate, but once we start dropping below 85 megawatts, with the take or pay, how much fixed costs do we have to pay that we wouldn't have to pay in the current contract where there's no take or pay?
Got it. And I'm going to start by saying it depends, but because it does. But if the reference point, and I intentionally actually stuck with the reference point being the new PPA, because that relates to the projected savings under the new PPA,
and that's fair.
Which is what we've been talking about. Right. But I think I wanted to answer the question you just asked, and so I want to talk about it. But I'll get to that. The floor provides that we'll buy 85 megawatts. If we never hit the floor, nothing changes. If we do hit the floor, OUC gets paid for 85 megawatts. If relative to our projected costs under the PPA, say in 2016 and 17, when the floor is 85, when the estimated purchase is 85 and the floor is 85. If our peak demand were to change, our billing demand were to flow through and change, time out. in 2017, the projected demand charges at 85 megawatts are $10,596,270. Relative to the new PPA, if our demand falls below 85 megawatts, we will still pay exactly $10,596,270.
All right.
The rate will be higher because we'll be paying for let's say 80 or 75 or 84 or whatever it is, but it will sum to exactly the same revenues. Let's look at an out year, let's say 21, or let's say 20, when the projected billing demand is 90 based on our conservative projected demand growth. If it's 90, then it's never implicated. If it's less than we project and it's 85, then it is what it is. But if it falls below 85, then we would, if it falls to 85, in the calculation of what the demand charges are going to be based on for the going forward year, we would actually be paying less than the $11,486,610 because we'd be paying for 85, not 90, which is what that number produces. And then if it falls below that, we'd still be paying $11,486,610.
Yeah, I guess I was looking to see what impact it would have on the rates because you're spreading it over a smaller base.
That's right, and that's the question. The question is, there's two issues here. One is, what's the impact of the demand falling, and the separate issue is what's the impact of sales erosion. We don't think it's likely, and that's explained elsewhere. Mr. Harrington and I talked about this at some length.
I know you guys. Okay, all right. Let me just give you a point because you brought that up. You keep saying that, but I produced a graph out of the CAFR that shows that we have lost 8.2% from 2005 to 2014. They're real numbers, 8.2%. And you guys are saying, well, we don't think that's going to, the erosion's not going to happen. It's going to go up 0.5%. We have history that says that.
Well, it could happen. We had the Great Recession during that period that accounted for a good chunk of that.
But we've come out. But that's no. I have to push back on that point because this is point to point. So we were at just under 768,000 in 2005. We've had an economic recovery, and we're at 705 now. That's a drop of 8.2%. You're correct in between; it dropped lower, but it came back. But even in spite of that, we're still down 8% over the period.
We are. We looked at what other utilities in Florida are projecting. They are projecting greater growth than we are. We chose conservative assumptions. But regardless, that was a prefatory remark, and we believe it's true. We think it's less likely rather than more likely. But if we fall below the floor, we're still paying the same.
Right.
Then it would be in that scenario an impact. There are some reasons to believe that even if there is some sales erosion, say due to solar penetration or other factors, that we might still not fall below the floor because solar is not going to impact our peak demand very much because we peak in the wintertime, early morning, early evening, when solar is not producing. So our real demand probably would not be affected by that. There are other factors that could affect that. The separate issue, though, is sales erosion. If there is additional solar penetration or additional efficiency measures or people just change their thermostats, they change their behavior, whatever it is, then there's sales erosion. That's erosion of KWH sales, which will have an upward pressure on rates. If there were to be some new technology, we talked about this in another memo that you have, small on-site gas-fired generation is not cost competitive. The only thing that really works in today's world is combined heat and power, where you've got a heating load where you can use the combustion energy from the natural gas or gasoline or propane or whatever it is. You can use the combustion energy to drive an engine or a turbine, microturbine, whatever. You can drive an engine to spin a generator, make electricity. use some excess heat to power chillers of some sort or other, whether it's a heat pump or absorption chillers. If it's a big unit, make some cold water for air conditioning, and recapture what's left for hot water. That's where you really make your money as a purveyor of combined heat and power. The only entity we've got on our system that really meets that is the hospital. The rest of the folks, Publix, Walmart, the sheriff, whatever, they don't have a hot water load, so CHP isn't going to work for them. Small gas-fired power is not going to work for them.
Okay, you represent the Retail Federation, if I remember
I do.
Correctly.
Yes, sir.
Are the Walmarts and Sam Clubs looking at this hard in terms of trying to generate their own power? The other entities like that?
Yes, sir. But not typically for microturbines. They particularly like solar. Walmart has extremely aggressive pro-renewable policies, and they are all about renewable and solar. But like I said, solar is not going to impact the minimum, is not going to affect very much, if at all, the minimum take provision under this new PPA. Let's just say if Walmart, it's complicated, but just assume that all the big box stores and the mall were to put solar on, it probably doesn't affect our peak demand, because they're still going to need backup power at the time of the peak in the early morning or the early evening. It will, separately, the sales erosion from that will sell fewer kilowatt hours, will have upward pressure on rates, but it won't be due to the minimum take provision. It'll be due to the fact that people are buying less. The minimum take provision only kicks in if our peak demand reduces to the point that it kicks in. If our peak demand doesn't reduce, and we're projecting it to grow very slightly, but if our peak demand doesn't reduce, then the floor never comes into play.
So the take or pay isn't reference to the base load, then, is what you're saying, or linked to the base load.
It doesn't affect the take or pay. Does not apply to energy purchases. I'm not sure that's the. I'm not sure that's the question you were asking. I'm trying to.
Okay. All right.
I'm trying to answer the question you were trying to ask.
Yeah, I agree. Okay. All right. I have to think about your answers a little bit. Okay.
Any questions?
So there's. If it happens, yeah, there's an impact. The dollars don't change, well, depending on what the erosion is. And then there's further potential offsets due to stranded cost recovery. If we were to hypothetically agree to sell the Shores business to FPL, we would ask for an amount of money take it back. My advice to you, as somebody who's been doing this a long time, would be very simple, and that is that to keep all the rest of your customers whole, you should ask that the purchase price include an amount sufficient to compensate the city for the costs that would be shifted by the departure of the Shores kilowatt-hour sales. That would be my advice, not my decision.
I saw that. Questions? You want to offer your motion?
Mr.
I'm sorry.
Wright wants to go through this last piece of.
Oh, okay.
Yeah, I
wants to summarize this.
I was going to walk through the table that I prepared at Councilmember Turner's request. She asked for a side-by-side comparison of the impacts of the various major provisions of the PPA on OUC and the city. And the lower base demand and energy charges, OUC loses $49 million. These are nominal numbers because it's easy to calculate and easy for people to understand. They lose $49 million of demand charges, which is the difference between the existing PPA and the new PPA demand charges. We correspondingly get a benefit of $49 million in the 16 to 23 period. We get an additional benefit in the 24 to 29 period of $43.2 million, which is the difference between the existing PPA demand charges and the projected market demand charges. OUC would the estimate would be that they would lose. There's a typo. That 0 should be a closed parent. They estimate to lose $43 million as the difference between existing PPA and the estimated market value, because presumably they could resell that capacity at the market value. We assume that energy costs and revenues are a wash. That's a good assumption. 24 to 29, we just covered a little bit. We get energy cost savings in 24 to 29 as compared to the OUC PPA of an additional $18 million. We just talked about the billing demand floor, and we can talk about capacity deficiency. All I can say is the capacity deficiency provision is unlikely to apply. If it does, then we pay extra based on whatever it is. It's either OUC's demand and energy costs, or it's their highest cost market, or it's the actual cost, their highest market cost, subject to a limit of actual costs as they agreed to 2 weeks ago. I think it's worth noting that there's only been one month in the last 69 months since January of 2010 in which we would have been capacity deficient as compared to the current, what will be the capacity deficiency threshold of 191 megawatts, and that was a 198 megawatt load that we hit in January of 2010, so we would have been 7 megawatts capacity deficient there. The consideration that we got for agreeing to the capacity deficiency surcharge from OUC was the ability to reduce our peak demand that factors into the billing demand by 10 megawatts, which is worth in 16 $1.3 million a year. The value changes from year to year because the demand charges change from year to year. OUC does replace a lot of the revenues they lose in agreeing to the reduced base capacity charges. They get peaking capacity revenues of $37.8 million over the 2016 to 23 period. We pay an extra 42.6. That includes energy costs, but we save a net of all what the whole big blue costs minus the cost of the OUC purchase and what it costs us the continuing cost of Big Blue, the $2.9 million plus $832,000 a year. We save a net nominal of around $6 million. So even the peaking capacity deal viewed as a side deal is a benefit to the city on a standalone basis. You can't view it standalone because it's an integrated deal. I think we've covered the change in law provision. Force majeure is now bilateral, which is a slight detriment to OUC, a slight benefit to the city. Avoided litigation costs, who knows? I will tell you that I discussed these with Mr. Frost, and depending on what court you were in and what the issues were and what the litigation was, he agrees that something on the order of $2 to $4 million per side could be saved. And we've pretty much covered the FGT contracts. So, I've talked about this some before, but all in all, if you just look at the numbers, OUC has given up more than they're getting. But they get additional value. They get the benefits of a shorter term, which would alleviate their need to add capacity. If they were to come out on the wrong end of a clean power plan decision that required them to shut down one or both of their Stanton coal units, they would have to add capacity. Those are 400 megawatt units. If they lost one of those units, they would have to add capacity under any reasonably foreseeable scenario. They wouldn't have to add as much, given that they would be out of the business of selling us firm capacity. So there's some risk mitigation benefit there. They get the capacity floor, which does provide some risk protection to them, and they get the gas transportation contracts. They, like we, I'm going to use the vernacular term that I am fond of using in this scenario, they, like we, avoid the train wreck that a lawyer beneficial countersuit scenario would engender. They see value here.
They definitely see value here, as do we. The dollar value to us, I think, is very clear. And when I say us, I mean the city and all of our customers, as I've said many times.
Right.
Mr. Wright?
Sir.
Any other questions from the Commission?
Yes, Mr. Chairman, for Mr. Wright. We've been talking all along about default based on economic questions, if the power usage goes down or the whatever. Mr. Wilson was talking about what happened if there was legal changes and we would be forced to litigate. Are we not in the same position there to evaluate what it costs us to litigate versus the benefit and default on the contract with the same costs or with whatever the appropriate cost would be?
I think the answer to that question is yes. But remember the rest. I apologize, vicariously for myself. Well, for myself and vicariously for my counterparts with whom we negotiated this language. But it is some detailed lawyerese. I'm not trying to get it, but let me get to the relevant point, and that is this: that provision protects us, the city, and all of our customers against the stranded cost liability under this contract that we would incur if we didn't challenge, or if we challenged unsuccessfully. We would be on the hook to keep paying for the peaking capacity and keep paying for the base capacity at the 85 megawatt floor, whatever implication that had. This gives us the out of being able to reduce what we have to pay for, but it imposes the condition on us to be able to exercise that out, or that glide path, as I call it. But it imposes the obligation on us to be able to exercise that of having to litigate. You could make the decision not to litigate, and then you could see where that lawsuit fell out.
No, I understand
I'm not advising you to do that, but...
I understand that. That's why I said that taking into consideration the economics of that part, it clearly may not be in our interest to default, but we always have that option if at some point we decided that it was beneficial. So we're not stuck you can suing or defending ourselves from our own citizens.
And that scenario is a curious one anyway. I don't know that an
don't
act,
disagree.
I don't know that an act by the city per se could be construed as a change in law giving rise to our obligation or ability to invoke these provisions under 15.11.2.
But it does commit us to lawsuits beyond matters of stranded costs. I mean, it's pretty broad.
It commits us to... let me say it this way. It commits us to lawsuits against actions that prevent our ability, the city of Vero Beach's ability, to perform this contract in the event of a change in law that's so extreme as to significantly adversely affect our ability to perform this contract. Our ability to perform this contract, or our inability to perform this contract, would potentially, absent this provision, leave us with cost responsibilities to OUC. It's not the technical definition of stranded cost, but it really is a stranded cost type of event. And actually, it could be stranded cost depending on what the legal action was. If the legal action was hypothetically retail choice, that would adversely affect us. We could theoretically be required to litigate against that, but because retail choice has, as I said earlier, in every instance of which I am aware, included stranded cost recovery protection for the affected utilities, we would get in line with the other retail serving utilities in Florida and say,
we want stranded cost recovery to be embedded in whatever our distribution rates are going forward or however it shakes out. So it really is kind of a stranded cost. Our liability to OUC in that scenario really, in most likely scenarios, is a stranded cost liability.
On behalf of the Finance Commission, of course, the Utilities Commission can go further. Mr. Provant, you wanted to make a motion?
I'll make a motion on behalf of the Finance Committee to approve this new PPA amended deal with OUC. And I'll suggest the City Council move forward on the contract.
Commissioners of the Finance Commission, do you have any inputs?
As your attorney, you might need a second, but go ahead.
Oh.
Mr. Chairman, there was one piece in here that I believe Mr. Wright suggested that in the consideration that even though OUC offered, we were advised not to accept. I believe the motion is to accept it as it was originally written. Is that correct? The amendment?
Just to be clear, with the 3 modifications that OUC previously agreed to.
Correct.
Okay.
Yes.
But not what we had just sent you back to try and renegotiate.
Also correct. Yes, sir.
Yeah, what's on the table? I need a second. Do I have a second?
Oh, I'm sorry. I'll second it for discussion.
Discussion? Heather, do you...
Mr. Chairman, from my perspective on both of these joint committees here today, we are here because we feel a civic duty to help our community, and I believe that we all have the community's best interest at heart. Even though we may use the term city, we're talking about city residents and the well-being of our city. I believe that we find ourselves in a situation of not of our doing, but we are here, and what we need to do is, I think, address where we are here and not how we got here. We have to deal with the issues at hand. Any contract that I've ever had the opportunity or displeasure to work with is never perfect on either side. I certainly would have always wanted to have a little more on my side than they have on their side, but that's negotiations. I think we are here today to make a decision whether we move forward or not with this particular contract or amended contract. I don't know that we could, after months and maybe years of discussion, get a better contract. As I understand, they may walk away, they could walk away and leave us with what we currently have in place, and then we revert to all those other issues of default and so forth. So I think we are here to do the best we can given the information we have, and while I would like to see the contract better on our side, I'm not sure we could get there with extended negotiations. That's my comments.
You want to call the question? From poll the...
Okay. Mr. Gorey?
Yes.
Mr. Brevant?
Yes.
Ms. Barton? Yes. Mr. Powers?
Yes.
Mr. Stump excused himself for a commitment. Based upon that, I make a motion that the Finance Commission adjourn. Second?
Second.
All in favor? Voice?
Aye.
Aye. Thank you very much for your service. And thank everyone who was involved for an arduous and, I think, very thorough review. Thank you.
All right.
There you go, sir.
On the same subject, Utilities Commission, would anyone like to entertain a motion on the subject?
Well, we have to make a decision, so I will move that we recommend the same motion to the City Council from the Utilities Commission.
Is there a second? A second. Any further discussion?
Yeah, I just want to state for the record, as I make my vote against it, I feel like that I've not had and the other members have not had the opportunity to vet the numbers sufficiently through the spreadsheets, that the requirement for the non-disclosure agreement was so onerous that I didn't want to take on a personal, legal, and financial risk. And for that reason, I'm going to vote against.
Okay. Any further comments? Would you poll the members?
Sure. Mr. Shute?
Yes.
Mr. Stratton?
Yes.
Ms. Orcutt? Yes. Mr. Arwell?
Against.
Ms. Moss?
Against.
For.
And Mr. Heskett? I'm sorry.
Yes, he said yes. What's the
Motion passes.
the motion passes? What's the vote? 7 to 1.
I think it was
7 to 2.
I voted against.
I got 5-2. Did I miss some? Heather? I got 5-2.
What's the count?
I got 5-2.
7 members, 5 to 2.
Okay.
Yes. So corrected, 5 to 2.
If you don't have anything else for me, you might entertain a motion to rise.
Yeah.
Adjourn.
All right, motion to adjourn.
Second.
Second. We're adjourned.